Right, let's get underway then. Good day to you all, wherever in the world you may be watching or listening to this webinar. My name is Gordon Harris, and I want to welcome you to the latest, and in many ways, the most specific of our long-running IP-focused webinar series, The Life Cycle of a Smart Idea. We have followed our smart idea from its inception through choices about the best protection, branding, and advertising of the invention, and we've looked at its enforcement and commercial exploitation. For today's discussion, we start from the assumption that the invention has been protected by obtaining patents under the European Patent Convention. This means that our proprietor owns a number of patents prosecuted through the European Patent Office, which have been granted and have then in the usual way become a series of national patents in EPC member countries through the designation process. We also assume that our inventor has not finished innovating and there will be more patents to come. As most of you will surely by now know, in the biggest changes to the European patent world for nearly 50 years, a whole new patent system is arriving in Europe this year. I will leave the details to the panel, but in short, the opportunity will exist for pan-European litigation and enforcement, and alongside that, the opportunity to acquire the first genuine pan-European patent, a single right covering most of the territory of the European Union. Our aim today is to give you real practical advice about what to do in response to this major change. We'll look at the basics of the new system, the first key decisions to make as a patent owner, the impact on the commercialization of European patents, strategic decisions regarding patent management and enforcement, and whether the new unitary patent system is the right solution for new patents. Now, before we start, let's find out a little bit about what we're dealing with in terms of material here. How well informed do you consider yourselves to be as an audience about the Unified Patents Court and the unitary patent? So there's a poll coming up to you now. Are you very well informed, quite well informed, not very well informed, or do you feel as thick as a whale sandwich about this topic? How are we doing? Good to see some admission of whale sandwich thickness there, but the majority of people feel quite well informed or not very well informed. Only a couple of people have the confidence to say that they're very well informed. So there we are. Then we have definitely got something to teach this afternoon. Right, let's move on then. By the end of this session, our aim is that you will understand the new system, have a good idea about the decisions which need to be made, and some ideas on the best strategies to use under the new opportunities. The decisions required are not just for those in Europe to consider, they apply to everyone anywhere in the world who owns a European patent or is considering applying for one. To help me guide you through the details of the new system, I'll be calling upon a panel of experts from the UK, Europe, and Canada, each taking a slightly different perspective on the questions we will consider. So let's hear from the panel with a short introduction. Panel introductions. Michael, you go first.
Hi, everyone. My name is Michael Carter, and I'm a patent litigator based in the UK with a particular focus on the automotive and engineering sectors. I'm also one of our FRAND specialists, having been involved in some of the leading SEP-FRAND cases in the UK in the past few years, including a recent 5-week High Court FRAND trial.
Seiko.
Hi, I'm Seiko Hidaka. Like Michael, I'm also UK-based and work on all technical matters, which usually means patent litigation and also sometimes trade secret misappropriation disputes. Now, most of these matters that I have had the pleasure of working on has had cross-border elements, which really makes the topic of UPC really interesting. I feel very lucky to be practicing at this exceptional time.
Thanks, Seiko. Clémence.
Hello everyone, I'm Clémence Lapôtre. I'm based in France, in Golling Paris office. I'm specialized in intellectual property law with 10 years of experience as an associate lawyer, covering patent litigation in complex and multi-jurisdictional disputes. I advise patent holders in various industries, including tech and software sectors, pharmaceutical and chemical industries, electrical and scientific equipment, or food processing. I am a member at the UPC Working Committee at Girling, of course, but also at the AIPPI Association.
Thanks very much, Clémence. Now across the Atlantic to Canada, and Anthony.
Hello, everyone. I'm Anthony Dearden. I'm a Canadian patent agent and a European patent attorney. I practice out of our firm's Vancouver office on the Canadian West Coast. My practice is focused around patent drafting and prosecution for clients in the tech sector, with a particular emphasis on computer implemented and software technologies. A lot of my clients do file in Europe, so I certainly have been keeping a keen eye on developments relating to the UPC and the unitary patent.
Thanks very much, Anton. And finally, last but not least, Edith.
Hi, I'm Edith Penty-Gerards. I'm a qualified UK and European patent attorney, and I work primarily in the biotechnology and pharmaceutical sectors. I spent the first 6 years of my career prosecuting patents in Europe, and then in 2019, I moved to Canada to join Gowling WLG's Vancouver office, where I work with a range of North American clients to protect their intellectual property in Canada and across the world.
Thanks very much indeed. Thank you, panel. Right, I'm going to lead our panel through the issues by posing a series of questions to draw out the details and strategies that you need to understand. Please feel free to add your own questions using the chat box button at the bottom of the screen, and our panel will be keeping an eye on that, and we'll try to deal with some of those questions as we go along. If we do not get to them all, we will circulate answers after the webinar. Also remember that we are having after the presentation portion of the webinar, we will be opening breakout rooms where you will have the opportunity to speak in smaller groups to our presenters about specific questions you may have. So please do stick around and follow the instructions at the end to join one of those breakout groups. Right, let's get started. Michael, can you set the scene for us? What is this new system and how has it come about?
Thanks, Gordon. I will try my best because the concept has quite a history, stretching back to the introduction of the UPC in 1973. Since this date, as most of you will know, patentees have been able to file a single application of the EPO for patent protection in all EPC member states. But because a European patent is a bundle of national rights, these patents need to be maintained separately, and separate proceedings are required in each country to either enforce or revoke them. There have been many complaints over the years that this increases renewal costs, enforcement costs, and of course, creates a risk of different courts reaching different outcomes in respect of the same invention. And this was considered highly inefficient by many who contrasted it with the successful integration of the Europe-wide system for enforcing European trademarks. Therefore, in 2013, agreement was reached on the Unified Patent Court and the European Patent with Unitary Effect, or the UPC and Unitary Patent for short. So taking the Unitary Patent first, this is brand new. It is a single indivisible patent right that will cover all participating member states. In this sense, it is similar to the EU trademark, and Ant will be saying more about this new right and its pros and cons later on. But I think it's fair to say that of the measures agreed in 2013, most attention has been focused on the UPC due to its impact on existing European patents. Clémence will be speaking about some of the detail later on, but in brief, the UPC is a new patent-specific court system for litigating both the newly created unitary patent and, subject to the opt-out, which we will cover later, new and existing European patents. It will enable a patentee to obtain, via a single action, an outcome that applies in all participating EU member states. In a sense, it brings the fragmented approach to patent litigation in the European Union into closer alignment with the approaches taken in other major economies, such as the USA and China, where issues relating to a patent may be determined in a single local court, but where the result applies across the entire country. In the UPC, a judgment from any one division of the court in any of the member states will apply in every other participating state for which the EP is designated. So that's the what and the why. But before we turn to the detail, I also wanted to briefly summarize who is involved, because it is not every country covered by a European patent. First, only EU member states can participate. As a result, EPO members who are not part of the EU, such as the UK, Iceland, Switzerland, and Norway, cannot be part of the UPC, or unitary patent. Even then, not every EU member state is participating. Croatia, Spain, and Poland are not taking part, each for their own reasons. And then there is another layer of complexity, because EU member states who do wish to participate need to have both signed the agreement and ratified it. And although they've had nearly 10 years to do so, a number of EU member states who signed the agreement in 2013 are still to ratify. Most, including Ireland, are expected to ratify at some point, but the Czech Republic, Slovakia, and Hungary may have reconsidered due to concerns regarding the impact of the system on their economies.
Thanks very much indeed, Michael. Now, it's a really sound foundation for the rest of this session. So let's move on to Clémence now. Clémence, how are things progressing in terms of the timescale? When is all this going to happen?
Well, given the long wait that Michael told us about, the progress of the UPC is now meteoric, Gordon. The key date to be mentioned here is January 18th, when Austria ratified the protocol on provisional application of the UPC agreement. So such ratification triggered on the following day, on the 19th, the birth of the UPC as an international organization, the coming into force of the protocol on provisional application of the UPC agreement, and the start of the provisional application period. The provisional application period should last 8 months, during which the preparatory work of the UPC will be conducted. So the main tasks are recruitment of judges, testing of IT system, and early registration of opt-out requests. We will speak about that later. Inaugural meetings of the governing bodies of the court, that are namely the administrative committee, the advisory committee, and the budget committee, have seen them adopt their respective rule of procedure and hence set their own legal frameworks. With regard to the forward-looking timetable, we can say that following the adoption of the budget by the relevant committee, member states will be called to make their first contribution. Money is indeed the crux of the realization of the UPC. At the end of March, recruitment of the UPC judges will start. In this respect, we can specify that the advisory committee, whose task is notably to interview and to train UPC judges, include judges from the French Supreme Court, but also from Paris Court of First Instance. German ratification is expected for June, which is quite soon, and the start of the 7-year transitional period during which the UPC and national courts will have shared jurisdiction is expected for October of this year.
Thanks very much, Clémence. So there we are. Obviously, things have been fairly fluid on timing, but October of this year is the expected start date as things stand. Right, before we get into the detailed issues, let's nip across the Atlantic for a first view from outside Europe. Anthony, you said you've been following all this fairly closely. So what are the questions which have occurred to you as you look to advise your clients about this new system?
Thanks, Gordon. So as Michael explained, the UPC is a brand new court system, and it's going to impact anyone who has a European patent or anyone who's thinking of applying for a European patent. And so even from a North American perspective, there's really no hiding from the UPC, and it's critical to be prepared for when the UPC eventually comes into force. In fact, I think all European patent owners are going to need to develop some kind of IP strategy for dealing with the UPC. And generally that strategy is going to involve taking some proactive measures before the UPC goes live. So one of the main questions on my mind is, what actions are my clients going to need to take before the new system comes into force? Now, as Seika will be explaining shortly, there's an important opt-out process for those who want to delay being drawn into the UPC system. And I think that properly managing and taking advantage of this opt-out process is going to be a central feature of any UPC strategy. Another question on my mind is how to advise clients on whether or not they should be taking advantage of the new type of patent that's going to be introduced later this year. This is the unitary patent, as we've heard. As most of you probably know, traditional European patents upon grant split into a bundle of national rights that can only be challenged or defended on a country-by-country basis. On the other hand, the new unitary patent is a single patent right that covers multiple European jurisdictions. So an important consideration is whether this new type of patent is actually the right fit for your European IP strategy. Now, yes, with the unitary patent, you will soon be able to get cost-effective, wide-ranging European coverage. But is that on its own enough to justify the fact that the unitary patent is vulnerable to a central revocation action? And how did the nature and commercial value of the technology that's protected by the patent, how do these play into the decision-making process? Another obvious issue with the unitary patent is that, as Michael explained earlier, while it will provide some fairly broad geographic coverage at an attractive price point, there are also some fairly big gaps in the protection that it does provide. So I'm thinking in particular of the UK, Norway, Spain, Switzerland. These are all countries that aren't covered by the unitary patent. Now, while you can add these on via traditional European patent validations, the fact that these countries aren't covered by the unitary patent could well mean the difference between opting for or avoiding the unitary patent. So I think that with that in mind, where a company usually validates its European patents is going to strongly affect the decision on whether or not to opt for the unitary patent. Lastly, let's remember that the UPC is a completely untested court system. So for a North American company or any company whose operations are focused in North America, an important consideration is that company's risk tolerance to European patent litigation. And this risk tolerance should be balanced against the main advantage of the unitary patent, which is wide, cost-effective coverage. I think that these are two of the main factors that should be front and center when it comes to building the unitary patent into your European IP strategy.
Thanks very much, Anthony. We're going to come back to the unitary patent again later. Now let's get into the detail. Just because you own a European patent does not mean that you are absolutely obliged to be drawn into the new system. There is an opportunity to opt out your patents. Before we look at the practicalities of that process, let's first look at the strategic considerations which might affect the choice. Seiko, can you walk us through the sorts of issues which might affect the decision to remain in or opt out of the UPC?
Sure, thanks, Gordon. Well, first of all, just on the practical side, opting out might be a hassle because it essentially requires you to input the relevant data into the UPC case management system, which is still being developed as we speak. We hope it will end up being a very user-friendly process, but in any event, efforts will need to be expended to make sure that all your patents are opted out if that's what you wanted to do. But putting aside the practical elements of it, the headline point I have for you on this topic is that unless you intend to sue on day one of the UPC system coming into play, there really isn't any merit in not opting out in the majority of the cases. That's to say, the best course for any patent holder is to opt out to your patents, at least those which are in force. I'm about to explain why, and there's a slide to help me show you what I'm trying to say. Now, the one point that I would like to drive home by this slide is that if you don't opt out, then the European patents will be within the UPC system by default, which means that a third party has a choice of venues from which to attack the patent. So if a third party wants to revoke all your parallel European patents in one hit, or make a declaration of non-infringement in respect of those parallel patents, then it can do that by starting an action in the UPC, which Ant has emphasized is an untested court. The third party can also, if it wants to, apply to centrally attack in the usual manner in the national courts. Now, opting the patent out of the patent system means that the UPC choice is removed and you force the third party to litigate in the national courts. It essentially removes the ability of the third party from going to the UPC to make a central attack on the patent. And there is no way to force a third party to initiate an action only before the UPC unless you obtain a unitary patent. And as Ant and Edith will shortly explain, the decision on whether to obtain a unitary patent will generally be led by patenting costs considerations. But the same doesn't hold true for patent holders. Opting out doesn't mean less choice for the patent holder, generally speaking, because if the patent is opted out, the patent holder still can withdraw that opt-out to sue before the UPC. The one exception being where the third party has already initiated a national court action, in which case the patent holder has no option but to battle the case out in that national court. But if the patent holder is not in the driving seat, then the patent holder might prefer to have a country by country battle anyway, rather than defend a central attack. So that's why overall, a patent holder would be advised to opt out its patents, unless of course the patent holder wants to start an action as soon as the UPC opens its doors. Now, what I do want to emphasize here is that we're not recommending that parties should not sue before the UPC. All we're wanting to sort of highlight here is that opting out the patents first will remove the choice of venue for third-party aggressors without too much drawback for the patent holders.
Thanks very much indeed, Seiko. Now, you talk about hassle. Let's assume you do decide to opt out. I can assure you that the process is not as straightforward as you might think it should be, or as it seems. Michael, can you now attempt to navigate the complexities of the opt-out system? Where do you start?
Well, Gordon, let me start by saying where you finish, because the opt-out is not a permanent feature of the UPC. It's only guaranteed to be available during the first 7 years, which is the transition period, as we've heard. Unless the period is extended, then all European patents and applications that have not been opted out by this date will forever be part of the UPC. On the other hand, patents and applications that have been opted out will remain opted out for the remainder of their term. So turning back to where to start, and I think this is, as Seiko mentioned, to recognise that a European patent is opted in by default. Doing nothing means the patent can be litigated in either the relevant national court or the UPC as soon as the UPC goes live. And some patentees may wake up to a nasty surprise on that day, particularly if they haven't taken steps to properly prepare. So the good news is that before the court goes live, there will be a sunrise period of 3 months for patentees to record their opt-outs. We do not yet know when the sunrise period will start, but if the preparatory committee sticks to the likely timetable outlined by Clemence and Germany ratifies the agreement before the summer, then it could be as early as June of this year. And 3 months is not really a very long time, and companies that are not sufficiently prepared to file their opt-outs early in the sunrise period are taking almost as much of a risk as those who fail to make a positive decision one way or another. And this is because an opt-out is not effective until it is recorded at the registry. As a result, any unforeseen delays in registration caused by errors in the application or the registry being overwhelmed by the sheer volume of applications could expose a patent to a pan-European validity attack when the court goes live. So preparation is key in 2 areas. First, thought needs to be put into whether to opt out in the first place. And Seiko has already explained some of the things that need to be considered when formulating this strategy, and why the safest route for most companies will likely be to opt out their whole portfolio. But for some patentees, it may be appropriate to pursue a more nuanced strategy. They may, for example, have the resources and motivation to try to influence the court's approach on key issues. So they may want to leave patents in to try that out at an early stage. Or they may wish to become familiar with the court's approach and procedure before they're left with no option when the transition period comes to an end. Regardless of whichever strategy is ultimately chosen, these discussions and decisions take time and will have long-lasting consequences for the enforcement, licensing, and value of the patents. And really, those discussions should be well underway by now. Second, the rules on opting out require patentees to be familiar with the detail of their EP portfolio, because applications must be filed by the patent owner or owners in order to be valid. And this will be particularly complex where the bundle is owned and managed by different companies. And where ownership is split, discussions will be needed to reach consensus on how to proceed. And Edith and Ant will be explaining how one might go about gathering and checking this information and formulating the strategy in a few minutes.
Thanks very much, Michael. But before you go, don't back away yet. One quick further question. We know that you can opt back in again by removal of the opt-out that you've made. Can you then opt out again?
No. So once you have chosen to opt back into the system, that is it. You cannot change your mind again. So we will not see any UPC hokey cokey. And the fact that patentees can only change their mind once, I think should be factored into any opt-out strategy. And then that strategy should be monitored and updated on an ongoing basis.
Thanks very much indeed. Right, let's have another poll now. Let's get back to the audience again. Before we look at some of more issues, what is your first impression? If you own European patents or you advise people that do, how likely would you be to opt out from what you know so far? Would you be very likely to opt out, quite likely, not likely at all, or you're thinking, let me at it, I can't wait to get started in that UPC? Right, I'm watching the results come in here, guys. I think we're very likely to opt out. Yeah, that's up in the mid-70s to 80% range. Quite likely covers quite a big range as well. Only 7 people, so about 10%, 9% saying not likely, and nobody seems desperate to get to it. So I think we're going to be seeing quite a bit of opting out going on. Right, let's press on. Let's nip back over to Canada here for a first impression of what you'll need to discuss with your European patent owning clients if they decide to use the opt-out process. So Edith, what will you be recommending to your clients by way of managing this process?
Thanks, Gordon. Well, yeah, as we heard from the panel already, there's a lot of information to unpack here, and a number of different factors that patent owners will need to look at to make an informed decision whether to opt out or stay in the UPC. So not only for my North American clients, but for anyone who owns or is involved in managing European patents, my main recommendation really is to start reviewing your portfolio as soon as possible. Strategic decisions you make now could well affect portfolios for years to come and will shape your future IP strategy. So first of all, I'll be encouraging and helping my clients to make a list of all of their European patents, both granted and pending, and then start having some meaningful discussions as to what value each patent has to their business and what the commercial aims of each patent are. For patents of high commercial value, for example, covering a client's core technology, the most risk-adverse choice will be to opt out of the UPC to avoid risks of central revocation, at least in the early stages of the UPC until any administrative wrinkles have been ironed out and we have more understanding of how patentee-friendly the court might be. On the other hand, perhaps for patents covering more peripheral aspects of technology or product, clients might want to have the option to pursue central infringement proceedings and take advantage of the cost savings and procedural benefits involved in that. But I do agree with what Seiko said earlier, that the safest option really is going to be to opt everything out. And then, of course, you can opt to select patents back in when you're ready to start a central infringement action, for example, or to test out the court system, as Michael mentioned. The actual act of opting out itself is relatively easy. You file a request and there's no fee involved. But what's really important is that the opt-out request is valid. And this is where the audit comes into play again. Only the owner of a European patent can file the opt-out validly. Also, subject to any contractual agreements, it might be necessary to obtain consent from any licensees, particularly exclusive licensees, because, and I know Michael's going to touch on this in a bit more detail next, but by default, exclusive licensees have the right to initiate action at the UPC. So they're likely going to have their own ideas about litigation strategy. So if you have any patents that are jointly owned with another party or have exclusive licensees, these really need to be identified as soon as possible and discussions started to make sure that all parties are in agreement on the opt-out strategy. And finally, I'll mention that all designations of a European patent must be opted out together. So you can't decide, okay, I'd like France, Sweden, Switzerland to be under jurisdiction of the UPC, but maybe Germany to only be under jurisdiction of the German national courts. And this is where it can get more complicated. I'm particularly thinking about the situation that was mentioned earlier, where national validations are held by different parties or subsidiaries. And in a more complex ownership structure like that, again, you're going to need to get all parties to agree and file the opt-out together.
Thanks very much indeed, Edith. There's a very clear message coming here. The opting out decision and practice is crucial. It must be addressed now. Before we start looking at the court system and how to use it, the opt-out process throws up lots of interesting challenges for owners, particularly those who license their patents. As we've seen, only the owner of the patents can use the opt-out process. But in most jurisdictions, an exclusive licensee has the ability to enforce a patent or defend an invalidity action. So what challenges does this pose for the creation and management of license documents? Michael, can you take us through this particularly tricky issue?
Yeah, so this is an issue we've been speaking about for a few years now, ever since we first raised it in an article for MIP in January 2015. And unfortunately, despite our best efforts, our experience is that very few people have taken the steps needed to ensure that they are properly prepared from this perspective. And this is a concern because it is an issue that every patentee that grants licenses, and particularly exclusive licenses, under its patents will need to address. And it arises because most license agreements are unlikely to have the necessary terms for dealing with the control of opt-outs or who controls the ability to bring proceedings in the UPC. So take the example of a patentee that is granted an exclusive license under its European patents to a single licensee who happens to be an SME. Whilst the patentee may wish to opt out for the reasons Seiko explained earlier, that the licensee may have the opposite view, particularly if it is facing widespread infringement issues. The fact that an exclusive licensee can issue proceedings in the UPC means there is a risk that if the patentee does nothing, they will be locked into the system by virtue of litigation commenced by their own licensee. And the situation gets even more complicated where a patentee grants multiple exclusive licenses by field of use or geography. So to cater for the risk of disputes arising, which may then delay the opt-out being filed, patentees and licensees should be having conversations about the UPC now, and if necessary, adjusting existing licenses or agreements to ensure that the matter is properly addressed. And although the issue is particularly relevant to licensing arrangements, I think the same applies to companies involved in joint ventures, collaboration agreements, and those who use their patents for security. They will need to think carefully about the impact of the UPC on their arrangements and who controls whether the patent should be opted out. And for those who want to know more about this issue, I believe a link to our blog post, which links through to the MIP article, is in the chat, or you can join me in one of the breakout rooms after the webinar.
Michael, as if by magic, it has appeared in the chat line, the link to that article. Thanks very much indeed. Okay, now let's take a look at the court system itself. Clémence, can you take us through the structure of the court and the options available for starting proceedings?
Sure, Gordon. So first, concerning the court's framework, the UPC is a common court for participating member states, which consists of a court of first instance and a court of appeal. It also includes a patent mediation and arbitration center and a training facility for judges. The court of first instance is composed of local divisions, regional divisions, and a central division. So, as a general rule, any participating member can set up a local division. It being specified that additional ones can also be established depending on the volume of patent cases. This is why, for example, Germany has 4 local divisions. As per regional divisions, they can be set up by participating member states that do not wish to create a local division. The first member states to announce the establishment of a regional division were Sweden, Estonia, Latvia, and Lithuania, thereby creating the Nordic Baltic division based in Stockholm. The central division will be based in Paris with a section in Munich. Following Brexit, we all know that there will be no third section in London. So here you can see a map showing the UPC's different divisions and jurisdiction, EU-wide. Second, concerning the functioning of the UPC, individual cases will be distributed amongst local and regional divisions based on the place of infringement or the defendant's address or domicile. Within the central divisions, cases will be attributed according to the subject matter of the patent based on WIPO's classification. So Paris will be competent for patents relating to performing operations, transportation, textile, paper, construction, physics, and electricity. Munich will be competent for patents relating to mechanical engineering, lighting, heating, and weapons. The procedure before the Court of First Instance will in principle consist of a written, an interim, and an oral procedure, as Psycho will explain it with more detail later. The UPC comprises only one Court of Appeal, based in Luxembourg, and only one level of appeal. So it is throughout the Court of Appeal decisions that uniformity and consistency will be imposed on the first instance division's case law. First instance decision may be appealed in whole or in part within 2 months. Appeal will have no suspensive effect unless the Court of Appeal orders so. So the result is certain procedural matters, for example, decision in relation to interim measures will follow an accelerated timetable. Now we can move, I think, to the material competence. So local and regional divisions will hear infringement claims and grant provisional and protective measures. The central division will handle revocation action and declaration for non-infringement. So the result is, however, an invalidity action can be brought before a local or a regional division as a counterclaim. In such case, the local division will have 3 options. So I think that's a new slide. First, it may, with the parties' agreements, refer both actions to the central division. Second, it may proceed with the infringement action, but refer the counterclaim for revocation to the central division. Then the infringement proceeding will be stayed pending the outcome of the revocation action, but only if there is a high likelihood of revocation. And third, it may proceed with both actions, infringement and revocation. In practice, many cases are expected to be handled as such, and this approach is rather common for French lawyers, since in France, there is no bifurcation system in patent litigation.
Thanks very much, Clémence. Now, while Brexit may have deprived the UPC of the participation of the UK, its influence is certainly going to be felt in the rules of the court. Seiko, could you just give us a bit of a guide to some of the key rules in the Unified Patents Court and how litigation will be conducted there?
Sure, Gordon. The point being like a key guide, really, because the actual rules of procedure is relatively long and detailed, as you might expect. But a good foundational grasp of the new UPC procedure may be had by bearing in mind that there are 3 stages to it, being the written procedure, interim procedure, oral procedure, as set out in the slide there. Basically, they can be translated into exchange of pleadings, case management conference, and trial. So going on to the written procedure, one characteristic of the UPC procedure is the requirement that the parties really fully set out its position right up from the start. So that means setting out the facts that they're going to rely on, identifying the evidence in support, and critically also parties expected to elaborate on claim interpretations and reasons why claims are to be interpreted in that way. And the parties then have the option to respond to each other's statements. This will really significantly front load the costs of the litigation, but perhaps also may lead to early settlement discussions. Now, following the closure of the written procedure, we move on to the interim procedure, where the case management takes place at the interim conference, and the court decides how the case will be managed. And Clements earlier explained how the infringement and validity parts of the case may be progressed, perhaps together or separately, depending on the facts surrounding the case. The courts will also determine what the main issues are and when the oral procedure will take place, and the deadline for all the other steps to trial, such as the filing of evidence, what sort of evidence, having regard to the main issues. Essentially, what the court is trying to do is to really streamline the case appropriately. There is no US-style discovery as such, but it is possible to ask the court to inspect certain documents which the opponent might hold. And the court will also explore whether there is any way of settling the dispute without going further. Now, if that can't be done and the interim procedure is over and the parties submit the required evidence at the right time points, the proceedings will move on to the oral procedure, which is essentially the trial. Another characteristic of the UPC court procedure is that it's speedy. It will essentially be what the courts will try to do is to aim to get to trial within 1 year of commencing proceedings. And in most cases, that trial is expected to take no more than 1 day. So parties will really need to focus what the main issues are, and representations will need to be really quite pithy. There will be scope for cross-examining witnesses and experts by the court and the opposing party. The use of this expert evidence and the cross-examination possibility very much comes from the UK practitioner's desires, albeit cross-examination will be under the control of the presiding judge. And decisions are expected within 6 weeks of the hearing. They're really ensuring that the court, at least to the first instance, the decision comes very, very, very quickly after issuing the proceedings. There's some fiddly details on cost recovery, which depends on the value of the case. But in principle, the loser pays the winners reasonable costs up to a maximum of €100,000.
Okay, I think, did you just say 100,000? Because the figure.
Oh, sorry, €600,000. Sorry, I think I might have done.
Oh, we were short-changing people a little bit there.
Yes, sorry
anyway, it's
about
good
that.
to see the influence of the common law extending into such a civil law-dominated court, even if Ireland and Malta may be the only common law countries in the final mix when it happens. Michael, can we come back to you here just to add a few points about a couple of issues that particularly patent attorneys and lawyers will be watching out for, and what the position might be for some very, very sort of commonly controversial patent issues like supplementary protection certificates and standard essential patents?
Of course. So I'll just set out the three areas that I think I'm going to be focusing on in particular when the court gets underway. And the first area is jurisdiction. And the reason for this is there will be a wide choice of potential forums, particularly during the transitional period of the UPC. So for patents that have not been opted out, there is likely to be a race to seize either the jurisdiction of the UPC or the relevant national court as appropriate. But even within the UPC, there will be considerable scope for forum shopping. So the extent to which these issues are managed and how the court applies the rules on jurisdiction where there is a parallel action in another state are likely to come to the fore quite quickly, and something that I think everyone will need to have an eye on. The second area, which I expect companies to be paying particularly close attention to, is the court's approach to interim or preliminary relief. So a real advantage of the UPC for patentees is that some of the interim measures that were only previously available in certain European countries will now be available throughout all participating member states. And I'm thinking in particular of interim measures such as the French saisie contrefaçon. And I'll apologise to Clemence later for the pronunciation. I wouldn't also be surprised to see potential defendants make use of the ability to file protected letters with the registry in order to protect against possible preliminary injunctions. And then the third area is how the court approaches practical issues such as service, confidentiality, and disclosure. As all of us litigators know, often from painful experience, those less glamorous aspects of the proceedings can sometimes be the most important and keenly contested. And confidentiality and disclosure will of course be of particular interest to SEP owners who are involved in FRAND disputes. But obviously the biggest issue driving their choice of forum will be how the court approaches the availability of injunctive relief and the extent to which FRAND issues are taken into account. Although the court has quite a wide range of remedies available to it, its power to issue declaratory judgments is far more limited than that of the English or US courts. And for this reason, I expect the approach the court takes will be closer to that of the German courts than the UK. But even so, how the case law of the UPC develops alongside pending FRAND matters in the English, French, and German national courts, and not forgetting the role the CJEU might play, will be particularly fascinating. Just to briefly mention SBCs, that there is not currently a concrete proposal for a unitary SBC, and this may obviously affect the attractiveness of the UPC system. But I understand the Commission is focused on this issue and has recently opened a call for evidence that might see things change in the near future. So that is something to watch out for.
Thanks very much, Michael. You touched in an earlier paragraph there about the CJEU, the Court of Justice of the European Union. Now, earlier on, talking about the structure of the courts, we said there was only one Court of Appeal, and that is right. The role of the CJEU, however, will be to answer particular questions raised by the courts in the way that it already does from national courts of member states. And of course, it was that role of the CJEU that was the final nail in the coffin as far as the United Kingdom remaining in this system was concerned. So the CJEU is there and will have a part to play in this. Right, one last point then, but a very important one. On the very same day that the Unified Patents Court comes into operation, possibly October this year, so does the unitary patent system. Now, we all know, and we've heard already, that up to now, a European patent on grant splinters into a series of designated national patents under titles like EP-UK or EP-DE. When the dawn breaks on the first day, the UPC operates, an additional designation will be available called EP-UP. This will be a single patent which covers all the European Union member states which have ratified the UPC agreement. Obviously, that does not include non-member EPC countries like the UK or Norway, nor member states which have chosen not to ratify, like Spain and Poland. But as things stand, it would cover around 15 countries and a very large economic bloc. So, would you want to designate EP-UP and go for the first truly pan-European patent, or stick with the classical model and designate only chosen national states? I'm going to hand over to Anthony and Edith generally here because they're the experts in this field. Between the two of you, can you talk through some of the issues which will influence that decision?
Yeah, absolutely, Gordon. So as I mentioned earlier, cost effectiveness is probably going to be the main deciding factor around opting for a unitary patent or going for the traditional European national validations. Now, the early modeling is suggesting that the cost of renewing a unitary patent is going to be priced at about 5 or 6 times the cost of renewing your average national validation. So as far as renewal fees are concerned, with the unitary patent, you could get coverage in up to about 14 countries for the price of 5 or 6. Not only that, but the translation requirements for the unitary patent have been simplified. And what this means is that you may be paying less in translations with a unitary patent than if you were to instead opt for multiple national validations, especially in countries with generally stricter requirements. Having said that, the renewal fees for the unitary patent do tend to climb steeply after the patent's 10th year. So while it may be possible to benefit from some cost savings or even substantial cost savings earlier on in the lifetime of the unitary patent, it's also possible for those savings to effectively be wiped out if you choose to maintain the unitary patent towards the full end of its 20-year term. Also, because the unitary patent is a single right, you can't elect to decrease the scope of protection that it confers with the aim of trying to reduce the amount of the renewal fee that you pay on the unitary patent. Now, on the other hand, that is something that you can do with your group of national validations, where as the patent term progresses, you can cost control those renewal fees that are payable by selectively abandoning certain national validations to cut back on those renewal fees. Now, clearly, each individual case is going to be different, and it's important to carry out the number crunching when your European patent grants in order to get a full picture of the potential cost savings that are on offer. So that was renewal fees. In terms of litigation costs, the UPC court fees are set to be higher than the fees that would be incurred at the national courts. So litigation via the UPC may cost slightly more when compared to litigation at a single national court or for a relatively lower value case. But when you consider the costs of litigating national validations across multiple jurisdictions, I think that that's where the cost effectiveness that the single forum provided by the UPC is going to be felt more strongly. Also, as Seiko, I believe, explained earlier, remember that the UPC sets a relatively short timeline between the filing of the claim and the rendering of the decision by the court, which should be about 1 year. So what this means that the costs of litigating a patent at the UPC are going to be much more compressed than if you were to pursue the same litigation by the national courts. Edith is now going to take us through how the unitary patent affects licensing considerations.
Thanks. And yes, well, the fact that the unitary patent is a single asset and can't be split up is quite important, because it means that unlike traditional European patents, it won't be possible to have an ownership structure with one owner in one country and another owner in another country. So it means that we'll need to be a bit more creative with license agreements for unitary patents to resemble that of different owners in different countries. For joint applicants, the order in which the applicants are named on a unitary patent is also significant, because it determines what laws are applicable to the unitary patent as an item of property, so for licensing and transfers. And generally, the applicable law is going to be the country of the first named applicant's place of business on the date the patent was filed, or if that determination is unclear, German law will apply by default. So the relative advantages of going down the unitary patent route rather than the traditional European patent route, as Ant said, will of course be different for different patent applications in a portfolio. And actually many of the pros and cons of pursuing unitary patent are similar as for deciding whether to opt out of the UPC or not, which were discussed earlier. But bearing in mind the fact that quite few European patents actually are litigated during their lifetime, I do expect that for the majority of applicants, cost will be the key deciding factor in choosing the unitary patent or not. From a practical point of view, I know a question that a lot of clients will be asking is, how can you position yourself now to take advantage of the unitary patent? Well, we know that once the sunrise period has begun, there's going to be two ways to do this. So one route will be you'll be able to file an early request for unitary effect once the sunrise period has begun. And the other way is that you'll be able to request delayed grant of a patent application until the unitary UPC is in force. And then you'll have a further 1 month to file the request for unitary effect. And although in the lead up to the sunrise period, there won't be any formal mechanisms for delaying grant, there are informal ways to delay prosecution. So if you have any European patents in the late stages of prosecution, then I do suggest talking to a patent attorney to discuss ways or whether it's possible to slow down prosecution in any way until the option for unitary patent is available.
Right, well, thanks very much to all the panel. There we have it. A brand new court system and the first pan-European patent. These are pretty significant changes, offering a range of options and some key decisions for European patent owners and prospective owners. This has all been about genuinely practical advice, so I want to give our speakers one more chance to give you their favorite key piece of advice about how to respond to the impending system. So over to you, Michael. Can you keep it fairly quick, please, speakers, because we're on time.
So this is slightly self-serving, but I think during the early years of the court, the composition of the legal team will be key. As we know, the UPC is a product of multiple legal systems, and judicial panels will be multinational to a greater or lesser degree. And with this in mind, I think my advice would be to strive to build a legal team that can draw on the experience of lawyers from a range of legal traditions so that they can game out what arguments may be made and how they might be received by this new court.
Thanks very much indeed. Anthony.
Yeah, I'm generally of the opinion that a better safe than sorry approach is probably a good bet. No one really knows how the UPC is going to play out in practice, so you might want to consider an across-the-board opt-out strategy for your entire European patent portfolio to shield it from the UPC. Remember that just because you opt out a given patent from the UPC doesn't mean that you can then at a later point, does not mean that you can then at a later point regain access to the UPC by withdrawing that opt-out. So you can take advantage of that rule. But absolutely start auditing for the opt-out process now. You don't want to be caught out a few weeks or even days before the UPC goes live and not have that opt-out strategy finalized.
Thanks very much. Very sound advice. Edith.
Yeah, I think I'd reinforce what Ant said in that patent owners should really be proactive in the opt-out process. So take the first step to contact your patent attorney or lawyer, get your list of European patents in your portfolio and start the discussion. I'd also recommend keeping an eye on your opponent's activities on opting out and filing unitary patents, just to understand their strategy, but also be aware they'll probably be keeping an eye on your actions too.
Certainly will. Clémence.
Yes, I would advise anticipating the possibility of bringing or defending actions by familiarizing oneself with the UPC rules of procedures. And as highlighted by Saiko and Edith, the UPC coming into force calls for an audit of one's own patent portfolio, but also maybe auditing competitors' patent portfolios in order to assess the risk of revocation or infringement action at the UPC. Such diligence would allow to ascertain whether the filing of a protective letter is worthwhile, or even if the strategic filing of an action at a national court to block any UPC central attack could be relevant.
Thanks very much indeed. Saiko.
So we all know how much businesses spend and invest in trying to get to really innovative inventions and hiring skilled people and providing expensive infrastructure. And I think that's why it's really important that patent holders can feel that their patents are examined carefully before the UPC. The interesting thing about the UPC is that there'll be oral expert evidence, as I've described, and there'll also be technical judges and also a possibility of having court-appointed experts. And at the moment, it seems to be a bit like a black box. We just don't know how they will interact. So I think what we will want to be doing is to watch with interest how the quality and the consistency of judging across the board is like, and really looking at the quality of all those recent decisions. And if they could achieve a very consistent view across the board and it becomes very predictable, then UPC has, I think, every reason why it would be successful.
Thanks very much indeed, Saiko. Just if I can catch up with the panel here with a couple of questions that have been raised on the chat line. Edith, I think it was you that said that the applicable law was going to be down to the nationality of the first named applicant. What if they're not European? Someone's asked me the question here, which I throw at you. What if it's Canadian?
Yeah, I think that, so you'll look at the first named applicant's place of business, and then they'll look at any co-applicants, and then if not, German law applies by default. Wow.
Okay, so the Germans have done well there. Another question that maybe for you or someone else I don't know, Saiko maybe, can you opt out an expired patent?
Yes, you can. There probably isn't much reason why you want to opt it out, because it's unlikely that the third party is going to revoke it because it's already expired, and nor will it apply for a declaration of non-infringement. It might do. I mean, the chances of them making a central attack is unlikely. So it's probably a rare instance where it doesn't really matter whether you opt out or you don't. Okay. As I say, you can always withdraw the opt-out if you want to enforce the patent in the UPC. So it doesn't really matter for the expired ones. It's possible if you want to do that.
There's one other question one other question I'm not going to get to now, because I want to ask the audience a question before we go and break into the chat rooms. Third poll question then. Now you know so much more about the system, how it works, how to opt in or out of it, the potential of the new pan-European designation. How do you feel about this new system? Do you feel positive? Do you feel very positive? Do you feel quite positive? Are you indifferent to it, or will you be avoiding it like the plague? How are we looking? We have got a few people saying they will avoid it like the plague. Indifferent, somewhere between quite positive and indifferent seems to be the bulk of the answers, though kudos to the two people who have weighed in with very positive. Thanks very much for your enthusiasm, we value it. But there are, to that end, 9 people saying that they will avoid it like the plague. So there we are. Right, thank you very much indeed to our panelists for today. I hope you all feel suitably well informed and ready to go off and plan your strategy for the forthcoming UPC. That marks the end of the formal panel, and we will open our breakout rooms very shortly, where you have the opportunity to chat with the panelists in a bit more detail. To join a breakout room, just click on the breakout rooms button at the bottom of your screen in the meeting controls and click on the room you would like to join. They're divided up by topics. You'll then be automatically brought into that room. If you need any assistance, please indicate the breakout room you would like to join in the chat function. A full video of the webinar will be posted on our website within the next week if you want to hear it again, or to share it with colleagues within your organizations. Next time in this series, we'll be looking at the very tricky question of legal privilege. So look out for that invitation coming your way soon. Thank you very much indeed for your kind attention today and taking the time to join us as we continue to explore the life cycle of a smart idea. Thank you very much indeed.